And so as I call your name, if you could just, or call your box, if you could just let me know what your name is and who you're representing here today. And so I'll start with AT. Someone under AT, if you could unmute.
Hi there. Yes, this is Amanda Chesterman. I am one of the homeowners.
Okay, great. Welcome, Amanda. Rich Brown.
I am Richard Brown. I am the general contractor and owner of Mike Brown Construction.
Okay, great. Welcome. Megan Gill.
Yes, I am a property owner surrounding
Okay,
neighbor.
got it. All right. And iPhone, gentleman under iPhone.
I guess there's a chance that's me. This is Jerry Chow. Is that did I come in under iPhone? Sorry about that.
That's you. No, it's fine.
Also, other property owner at 3878 Hyde Park Avenue.
Okay, great. So there's a little bit of housekeeping I think we need to cover here before we get into the substance of the hearing. So before I go through my whole hearing script and do all of that, I wanted to bring to the applicant and the owner's attention a objection that was filed on behalf of the Metropolitan Sewer District of Cincinnati. Have you all seen that in the case file, or are you aware of that at all? And anyone can answer here, either
Yeah, I can
Testerman or Brown.
Yeah, I can take that. Yes, I am aware of it. I've been working with MSD the last 2 weeks since that objection was filed to work out a solution. Apparently, that sewer line was installed prior to any records being made. There is no recorded easement. The sewer was there prior to the home being constructed, and currently they have no idea even where that manhole is. So we've been trying to locate that to find where the actual sewer line exists relative to the property.
Okay.
There is no recorded easement. There's really no record of the actual sewer itself, other than they can see the water flowing through it. So we've been working with them to locate that, and we are working towards creating some kind of resolution to where either we might adjust the footprint of the house to suffice what they need. And they're working with us in terms of their setback requirements. I've actually was just talking with Rob Kern before we jumped on this meeting, because we do have some updated surveys locating the potential sewer line where we believe it to be relative to the house. So we seem to be moving in the right direction on that front.
Okay, great. Well, I'm glad to hear that you all are talking and trying to work to some resolution on that. I think that the potential complication for the hearing today in regards to that is that if there is any adjustments that need to be made to the site plan or the design or anything related to this application, you would then have to come back through this hearing and reapply and start over. If we were to go through the whole hearing today and you were to ask for approval as is, one potential solution to that, which I think might be more efficient, is to continue this in progress. So continue this hearing today until the issue with MSD is worked out and you know for certain that your design and your site plan and your project is not going to change at all, based on whatever happens with MSD. Does that make sense what I'm saying? Because if we were to go through this and I was to approve it as is and then you changed it, you guys would have to come back through and it would cost you more time and it would cost you probably take more time and cost you more money. So I just wanted to throw that out there. I mean, we can go forward today, or if you're very confident, I would say that you're not going to have to change anything about this project based on MSD's objection, then we can move forward today. But I would say if there's any chance that there's going to be some change, or there could be a change based on whatever the outcome is with your MSD conversations, it's likely in your best interest to continue this case today.
Can I add just that much sense because this is the first time I've been in the remodeling business for quite some time. This is the first time I've run into this situation, especially where it relates to an existing structure and an existing sewer line that it really isn't of record. So my question would be, and from my conversations with MSD, we wouldn't be getting any if we had the variance for just keeping inside with the existing footprint of the house. The only thing that would adjust would be it would be the footprint would be moved further away from the property line. So if we were approved for the variance as called out currently, any changes that were done would actually have the existing or the addition inside the existing footprint. It'd be further away from the property line, still within the variance. So if we were approved for what's currently shown, anything that would change would actually be we'd be further away from the property line, not closer to it. I don't know if that matters or not.
So yeah, look, so I'm seeing that the relief, I mean, that's a good question. So seeing that the relief you're requesting today is a side setback variance of 2 feet. And is that it, Emily? And then a rear, is it a rear yard as well?
It's just on the side of the house, right? It's the 2 feet that we need, because we would be 5 feet from the property line instead of 7 if we followed the existing footprint of the house.
So Emily, how would, if the, and you're saying, I'm sorry, Mr. Brown, you're saying that if you did change anything, you would be more compliant with that side yard setback requirement?
Yes.
Or-
Yes. So essentially, if we change the footprint, any change we make would actually we would have that 7-foot side yard setback. We would be very close to that 7-foot side yard setback currently. The crux of it is they don't know where that sewer line is technically. So once we get in there and find it, we know we're not going to get any closer to the property line. We would just get further away from it. But they want that. MSD is just concerned that if something happens with that sewer line, they got to be able to get in there and fix it, which the homeowners are going to want that fixed as well because it services their house. But we would never get any closer to that side yard setback. Any changes we make per this variance that we're asking for now, we would only get further away from the property line. So we'd still be able to proceed. It would just, we wouldn't get any closer. So we wouldn't need, in my thinking, wouldn't need to have it reapproved because we wouldn't be changing. We would be further away from the variance we've already been approved for.
Gotcha. So Emily, do you have?
Yeah, I mean, I
add?
think, that's accurate in that if it has to be farther from that west property line, it's, there's potential that the redesign could be zoning compliant. I think it would be up to the applicants. If you think it's going to be a more substantial redesign that may trigger like a new rear setback variance, like it looks like you are somewhat close on the rear setback. It's, as the hearing examiner said, it's kind of at your own risk. If there's a substantial change that requires new relief, and you get the 5-foot side setback, then you would have to start the process over.
Yeah.
Emily,
Like if
can
you wanted to
just-
make up some of the lost space by going further towards the rear,
Sure, Emily, can you
you might
describe
push into that.
how
Go
far are we? I think we're significantly far from our rear yard.
Let me pull it up.
Because what we're looking at is we want to stay in line, the intent before we realize that sewer line is where it is, was to stay in line with the current footprint of the house, to match the style of the neighborhood and not have it look sort of wonky. And to come out 15 feet, we have a concrete patio in that area currently. We would be taking up most of that space, but not all of it. And so the intent was to stay within there. If we need to shift the house footprint farther east, instead of, I'm making this up, instead of it being a 2-yard setback, maybe it's a 1-yard setback. And so I think what we're asking is if we're approved for 2 and we need to shift it, and now we need a foot or 7 inches or something like that, would we have to come back through? If we're approved for 2, we'd be approved for that other small amount. understanding that if it changed significantly to where we're now have exactly 7 feet or even more than 7 feet, and we resubmit the plans, this negates the need for a variance in the first place.
Right, so if you shift it so that you don't need any relief, then, it's moot. You would just meet the zoning code, we'd approve the building permit. And if you are, basically it comes down to a staff determination of if it's a not substantial change or not. And so if you're reducing the amount of relief you needed, but generally just shifting the footprint over to be more compliant, I think that would qualify as a not substantial change.
I'd say
Right,
that's
and-
generally correct. But if you want to try and make up that lost square footage somewhere else,
But by going further back, right, that's the point, is if we go too far back, then we start worrying about backyard setback, which I thought we're fairly far from that space. And I don't think we'd want to add on much more off the back besides the 15 feet anyway. So from what I've heard the last about 5-10 minutes, it sounds to me like I'd still want to proceed with going for the 2-foot relief, knowing that if we do need to adjust a little bit further east, then maybe only use 1 foot of that relief, what have you. Of course, Amanda and Richard, you tell me if you think the same, right? But it sounds like I want to go forward with the hearing.
From what I've seen on the rear yard setback, I want to say it was like 100 feet from the rear property line.
Yes,
Where-
and I was looking at an initial site plan that had the dashed line, and I was thinking, typically that's demonstrating where the required setback is, but you do have a substantial, you're permitted to be 35 feet from the rear property line, and I think any small shifts are not going to take you to that 35 feet.
Yeah. Yeah, I didn't think so. It's a much deeper lot than what most people have in that area. And that's kind of the reason why this is all kind of surprising, because of the way the house sits on a lot, it really never should have been put there. But the way the house is shaped, but you can't do anything about that now. So
in the correspondence from MSD, they said that they cannot allow construction within 10 feet of the sewer pipe, and will not approve the building permits within 10 feet. Is that consistent with the representations, Mr. Brown, you've heard in
Yes
your
and no.
discussions?
So that is their standard boilerplate answer when they have an easement in place. It's at their discretion, since they do not have an easement in place. So technically they really don't have access to the property. So they're willing to work with us to make sure that they have room to work, and we're not make an eyesore for the neighborhood and for the homeowners. They are willing to work with that. There is an addendum in their bylaws that says they can have a 3-foot cushion up to 3 feet and still work, depending on the depth of the sewer. So we're working to see what that depth is, because they don't have accurate records. We've been out there 3 times to locate the manhole. With my survey crew, and MSD sent out their survey crew, and the best they can tell is they put a stake in the ground, and it's underneath a giant oak tree, is what they think it is. Where the manhole. So because we're still trying to figure out where that is and how deep it is, there's still some unknowns. But per MSD's recommendation, they said go ahead and move forward with the variance, because we won't get any closer to it. We would just have to get further away from that line. But as long as we're approved to stay within the existing footprint of the house, we shouldn't have any issues on their end.
Okay. When you say approved to stay within the existing footprint of the house, do you mean the proposal does not expand the footprint of the home?
It does no. When I say like it doesn't, we're not going. So if you look at the plan itself, we're not going any wider than existing footer lines.
Gotcha. Extend the existing non-conforming setback.
Correct.
Yeah. Okay. All right. So it sounds like you all would like to move forward then today with the proposal as is. Is that right? Okay.
That's yes
All right.
for me. Yeah, Amanda, Richard, I think you're in that position. Amanda, you as well?
I agree.
Yep. Okay.
Okay. All right. So I'm going to start by reading through our hearing script. This will just cover the procedure for the hearing. I'm glad we could work through all of that, but we have to do a little bit more structured for the rest of the hearing here. So I'm going to read through our hearing script that will go over the procedure and then we'll get into it. So this is the September 18th, 2024 session of the zoning hearing examiner docket. Again, my name is David Sturkey. I'll be presiding over the hearing today. Case before us today is case number ZH20240114. That's 3878 Hyde Park Avenue. The purpose of the hearing is to allow applicants and any other parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any other party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. For our purposes here today, I'll allow the two property owners and Mr. Brown an opportunity to tell me about the project. I know that we've already spoken a lot about it so far, but if you would indulge me for the record, if you could tell me about the project, what the relief is that you're requesting and why you think that relief is appropriate. I'll then move to the public. I'll allow Ms. Gill, if she would like, to provide testimony after the applicant has presented its case. I'll hear from the the planning department to provide any testimony in addition to their staff report if they would like. In the event that any party testifies or offers argument in opposition to this application, the applicant will have an opportunity to respond to that testimony that was offered in opposition. And then finally, the applicant will have an opportunity to make any closing statements. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. In the event that there are any technical difficulties with the Zoom technology, I'll do my best to troubleshoot those issues on the fly. But to the extent there's some defect that prevents us from meaningfully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay, last thing I need to do here is to swear in all of our witnesses. So if you intend on providing any testimony here today, making any comments, asking any questions, really doing anything other than just strictly observing, then the zoning code requires that I swear you in. So if that's you, if you can make sure that you are off mute now, I need everyone to raise their right hand and to answer out loud. Do you swear or affirm that the testimony you shall provide will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Yes.
I do.
Okay, great. Thanks, everyone. Now that we are providing sworn testimony as required by the rules, I will go ahead and turn it over to the applicants to tell me about the project and the relief they're requesting. And any one of you can go first.
Amanda, should we have Richard? Do you want to lead off, and then Amanda and I can fill in as needed?
Sure. So you're just looking for a general overview of the project? Is that essentially?
Yeah, whatever you think is important for me to know to make the decision, but in particular, the relief you're requesting and why it's appropriate.
Yeah. So what we're looking to do is the homeowners purchased a home in the neighborhood, and they are looking to expand their home office space and also put a first floor laundry room and a master suite above that addition. Currently just outgrown their house, and they are looking to stay within the existing width of their existing home and pushing it towards the back, just to add more room so they could grow into in their home as their family expands. Currently have one child now and looking to have more, and without being forced to move out of that location. They like to stay where they're at. They're happy where they're at. Want to look at improving their current space so that they can, move in and live, as long as they can in that location. And essentially, the design profile that we chose, it all matches what's currently at the house. First floor brick, siding on the concrete siding on the second floor to match the existing houses in the neighborhood. Everything complies with the type of material, and in the home, the overall design of the property looks like the homes in the neighborhood, and it will actually increase value for the neighbors. We're not encroaching on any lines closer to any properties other than the existing driveway. It's good where we are staying within the original framework of the plan, and all of the addition does line up with the existing walls. So we aren't going any closer to any neighboring properties than what's already currently there. So Jerry and Amanda, if you guys want to chime in, feel free.
Right, and maybe just
Terry,
to add.
if
Oh,
it's
go ahead.
okay, I'm going to jump in. So it's an old home. We live in the neighborhood of Oakley. We really enjoy the neighborhood. I think it's 1922 or something like that. So certainly the house was built prior to the current zoning rules that require this side yard setback. So we didn't build build the house too close intentionally. And really want to stay with the character of the home and the character of the neighborhood. Want to be able to maximize the space that we can. The reason we're not going back farther is because we have a really nice tree right behind. We don't want to bump it out really far and then have to take that down. But want to make it look like it matches the neighborhood. We understand that it is close to it's the property on our west side. We have communicated with them what our plans are, as well as our surrounding neighbors. As in understanding, we do have a growing family. We'd like to have really want to have a bathroom on the first floor with a toddler, as well as having more space to grow into that home and not have to leave the space or leave the city to find an affordable house in another neighborhood. We know that increasing the space in the house will increase property value, and for the city, that would also be property taxes. So it does increase, there are benefits for the city in allowing for this. Jerry, anything else that you want to add?
Yeah, probably just two other quick points. I mean, so it's a 3-bed, 1-bath today, plus the Cincinnati toilet in the basement. So we're hoping to go to a 4-bed, 2.5, right? Get one on the main floor, like Amanda said, which would really help us out and again, increase value and all that. And then as far as the numbers, I know we said this before, but just to restate what the setback we're looking for is. So today on the west side of the property, we are 5 feet away from the property line, right, with our neighbors there. So again, we want to extend straight backwards, so not going any closer to our west side property line, but to do that with it being 5 feet from the property line, that's why we need the 2-foot relief. So that's what we're asking for on, I think, a 15-foot back addition. I think that's all the details. So unless Rich or Amanda, otherwise I think that's what
one
we've got.
last thing that I think is very important that we recognize is one of the things about this property. I've done a lot of work in the city limits and Hyde Park and Oakley. They truly have one of the nicest backyards I've ever seen in that area. They won't be able to find that again. So if they were forced to move, there's no way they'd ever be able to replicate that in that area. It's truly is a one-off property. So I understand why they'd want to do whatever they can to stay there, because they are not going to find that opportunity again.
Okay, great. I don't think I have any questions. So unless there's anything else you all want to say now, I'll move to the public, and of course you guys will have an opportunity to respond to anything else that's said during the hearing. Okay, Ms. Gill, did you want to provide any testimony?
No, I do not.
Okay, all right. Ms. Ahouse, anything from city planning?
Yes, Matt Lashide, staff report providing an extensive analysis of this proposal, and we are recommending approval as consistent with the standards for variances. Our finding is that there are special circumstances to this lot based on the unique lot configuration and having an existing building that was constructed prior to the current zoning with a 5-foot side yard setback existing rather than the currently required 7-foot minimum side yard setback. So continuing that existing setback is really the most practical solution in the design of the floor plan and in terms of compatibility with the existing historic architecture. We also find that this is a substantial property right enjoyed by others in the vicinity. And just a review of KGIS maps and parcel lines, there are other similar reduced side yard setbacks in the vicinity.
Okay, great. Thank you, Emily. All right, anything you, the applicants, the owners want to say in response to Ms. Ahouse's testimony, or anything else in closing or otherwise before we adjourn?
No, I think everything sounded really positive. And I think there are also some letters, emails submitted as well from our other neighbors, right? So I hope you had a chance to take a look at those. As we said at the beginning, I think the only hangup is the MSD sewer line. And our hope is if we still get this very 2-foot relief, then we work out, once we know where the sewer line is, right? That's step one with MSD. Once we know where the sewer line is, we work all that out with MSD, and we either conform to the 2 feet that we get today, or even have to move further back, right? Which again would be even more in the spirit. So that's kind of why we're hoping for getting our relief today.
Okay. All right, great. Let's leave it at that then. I've had a chance to review the application materials and the staff report, and based off of that and additionally the letters from neighboring property owners, based on that and the testimony I've heard here today, I agree with the applicants on this, that it would be impractical to strictly enforce the zoning code to this particular application. So I'm going to approve the application. I need to formalize that approval in a written decision. I mentioned at the beginning that typically takes about 2 weeks. As soon as I finish that, I put it into a PDF and I'll email it to everybody who's in the hearing here today. So you'll have a copy of it really just moments after it's complete. Once Emily has that email as well, she can approve the zoning on her end, and you guys can take the next steps and hopefully figure out this issue with MSD.
Yeah. David, thank you very much. We appreciate it.
Yeah, absolutely.
Thank you guys. Thank you very much.
No problem. Thank you all again. I hope things work out with MSD. But you have the zoning approval on our end. So
Thank you. Appreciate it.
but best of luck.
Have a good afternoon. Yep.
See you guys.
Great, thank you.